In this case, we meet a woman charged with a violent felony, aggravated assault, with a deadly weapon. The courtroom starts with tension, as Judge Boyd highlights how one person's recklessness can disrupt an entire community. Felicia Cox is about to enter a plea, but the deeper questions are about her state of mind, her past, and her future.
People in a neighborhood, because let me just tell you what ends up happening. There's some person who's minding their own business in their neighborhood, just probably trying to have a relaxing evening, maybe barbecuing or something, and then they have to deal with all this foolishness with screaming and stuff going on, and people saying, I stabbed somebody because they disrespected my company. So there's not to be any contact. All right, you need to go over here. Your client is in the middle.
I'm afraid.
You are so funny. And CR 5820, State of Texas versus Felicia Cox. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Cleophas Marshall.
And are you Ms. Cox?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discoveries. Ms. Cox, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Judge, I believe we're proceeding on count paragraph A, waiving paragraph B.
Any objection?
No objection, Your Honor.
Did you understand what you're charged with is aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do believe she's mentally competent to stand trial.
Do you believe she's was sane at the time of the offense?
I do.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, the state is proceeding on count 1, paragraph A only. There's a $1,000 fine to be probated. Affirmative finding of deadly weapon. State recommends deferred adjudication. There's the restitution of $200 to Amber Times, Times. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
That is correct.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, has there been any such motions?
No.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 150 hours of community service restitution, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, state offers state exhibit 1 and its attachments.
We reviewed the state's exhibits. We have no objections.
Ms. Cox, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Excuse me, off the record. That's not filled out correctly. All right, Ms. Cox, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form, thank you, of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Have the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I've had an opportunity to represent Ms. Cox in this matter, and she is requesting that the court grant her application for deferred adjudication. I would show the court that she's taking care of her disabled child. And so we would ask that the court would consider lowering the hours of community service.
The guilty plea seals her fate, but her attorney pivots, revealing she's the sole caregiver to a disabled child. The courtroom shifts. It's no longer just about punishment, it's about a mother who might have lost her way under the weight of caregiving, stress, and something darker. Can her role as a mother shield her from the full impact of the law?
Or adjusting them.
Okay, you said she's taking care of a child?
Yes.
All right. So is there anything you wish to say, Ms. Cox? Well, what's going on in your life? Why would something like this happen?
I don't know. It was New Year's.
I'm sorry, I can't hear you.
It was New Year's.
And how old is your child?
He's 10
And where was your 10-year-old during this? It happened during New Year's and
with my mom.
see, if we would put our children first, maybe we wouldn't be here, right? So if you're drug tested today, what are the results going to be?
I was there.
All right, what are you going to be positive for? And what else? All right, you're going to get drug tested today. So you want to stick with just marijuana?
It says marijuana.
All right, so here's the thing. If it's more than marijuana, we're going to have some issues because you're being dishonest with me. When I place people on probation, my goal is for them to be successful on it. So if you don't,
If
yes.
I may, Your Honor, there's always a possibility that somebody could.
All right, well, let's do
replace it with
this.
something.
What's the possibility that you may be positive for something other than marijuana because maybe somebody put something in a cigarette that you didn't know about?
Maybe cocaine.
All right, so there's a possibility that it may be cocaine and what else? That, again, that someone may have put in a cigarette that you know nothing about. Okay, so cocaine, meth, and marijuana, and what else? Are you sure?
What begins as a simple marijuana admission unravels into something far more disturbing. Under pressure, Cox reveals potential use of meth and cocaine. The judge's demeanor changes. This isn't about recreational drugs anymore. It's about truth, trust, and the safety of a child who may have been living in a ticking time bomb.
All right.
They're always lacing the stuff with fentanyl as well.
Oh, there could be other things, you know? It could be other things.
Just
Okay.
let the court
All
know.
right. Because I don't, we have drug testing that we can do here today. And we can get an answer from me right away. But I don't like to spend money unnecessarily if we don't have to.
I understand.
All right, are you employed?
No, ma'am, I take care of my disabled son.
All right. So we're gonna have to come up with a better plan because I can't have someone who may be on marijuana, cocaine, and methamphetamine taking, well, I don't know why you're rolling your eyes at me.
Your Honor, if I may,
Mhm.
I think it's an unnatural or a natural demeanor or disposition of her. She tends to do it at all times.
Okay, here's the thing. I understand, and I understand that people make, no problem. I understand that sometimes people are nervous, but I can't have her, until we get this drug problem under control, I can't have her having unsupervised contact with a 10-year-old. So you're not going to be allowed to be alone with him, you understand?
Yes, ma'am.
So I want you to be honest with me. Are you really taking care of him,
Yes,
or it's his
ma'am.
grandmother?
No, me.
All right, so does his grandmother know all this that's going on in your life?
No, ma'am.
All right. So do you have a significant other in your life?
No, ma'am, it's just me.
All right. So this is what the court is going to do. It's going to be 2 years deferred adjudication, $1,000 fine, probated. I'm going to want her in felony drug court.
For the first time, the courtroom goes silent. The judge draws a clear, painful line. No more unsupervised time with her son. For a mother who claims she lives for her child, it's the ultimate blow and a wake-up call. The law is no longer just reacting to violence. It's stepping in to protect an innocent life.
You're going to be referred to felony drug court, and this dancing that you did with me about something that may or may not be in a marijuana cigarette, don't do this with them.
Yes,
Just be upfront and honest with them because you really need the help. Because otherwise, you know what's going to end up happening? You're going to end up losing custody of your son. Okay?
yes, ma'am.
So I want a referral to felony drug court. I'm going to want the UA hotline until accepted. And can you let felony drug court know this is an emergency?
Yes, Your Honor.
There's going to be $200 restitution and no contact with Amber Times.
Your Honor, if I may, on the no contact with Ms. Times, I've had an opportunity to talk with her, as have the state. In fact, she's in the courtroom at this time, and she is okay with there being a no harmful contact in the injurious, no contact in a harmful or injurious manner. They do kind of flow in the same areas, and so I would not want.
Where's Ms. Times?
Ms. Times, would you please stand up?
Ms. Times, there should be no contact. We can't have people stabbing people in a neighborhood because let me just tell you what ends up happening. There's some person who's minding their own business in their neighborhood, just probably trying to have a relaxing evening, maybe barbecuing or something, and then they have to deal with all this foolishness with screaming and stuff going on, and people saying I stabbed somebody because they disrespected my company. So there's not to be any contact. All right, thank you. So there should be no contact with Amber Times, $200 restitution. Ms. Times, do you still want your $200 restitution? That could probably help her out.
Yes, ma'am.
All right, so she still wants her $200 restitution. We're gonna do parenting classes. There should be regular reporting and probation. I'm sorry to do this to you, but I'm gonna need field visit 4 times per month to make sure that her child is okay and that she's not having unsupervised contact. There should be no unsupervised contact with minors. I'm going to want proof of employment within 30 days. There should be no employment as a home health care provider or minors. How are you supporting yourself?
I take care of my son, so it's on Social Security.
Yeah, that Social Security is for your son. It's not for you.
I know.
So, okay. I'm going to want 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do and you present proof, 40 of those hours will be waived. The remaining of the hours will be waived once you provide proof of successful completion of parenting classes. If she's not accepted into felony drug court, please let me know immediately. We're going to do something else. All right. I tell you what, just go ahead and do a tap as well. All right. Probation. Is there anything else that she needs?
No, Your Honor.
I'm sorry. Did I say report? Yes, I did say regular reporting.
Yes.
Is there anything else you need from the court in order to be successful? All right. You're going to have to do better for your child. State, what are you doing with 2020 CR 4845?
Judge, it will be dismissed, but not sure in what form, but we plan to get rid of it
All right, when is that gonna happen?
today.
All right, thank you.
And Judge, we have impact statement, so.
Felicia Cox didn't just face a courtroom, she faced herself. Her second chance comes with strings, supervision, and zero room for error. This wasn't just about punishment. It was about a justice system trying to intercept a downward spiral before it claims another life. What do you think? Did Judge Boyd strike the right balance between accountability and compassion? Drop your thoughts in the comments, and don't forget to subscribe for more real courtroom drama.